Good morning, and thank you for joining me on the path to liberty. I'm Michael Bolden with the 10th Amendment Center, and this is the show for Wednesday, August 30th, 2023. And today I'm talking about what I see as a very dangerous myth that's actually pretty widespread. And I got it from a tweet by Nick, or a X post by Nick Carter yesterday. And here's how he put it. The judicial system in this country is our last bulwark against tyranny. Now, mind you, he used all caps on the word last because he really wants to emphasize that this is the last way you can stop tyranny is through the court system of the government itself. Now, really, when you get down to this is actually emphasizing, and mind you, this is not an uncommon view, especially, and I think unfortunately, after people who take the position and generally in support of the Constitution and liberty, once they get like one or two federal court opinions that are moving things in their direction, all of a sudden it's like, well, let's wait on the courts. A lot of people take that position. They did before, and then they learned that's a bad choice, and now we're kind of seeing the pendulum swing again. Anyways, side note, this really is two myths in one. First of all, that the federal courts in and of themselves are the final and ultimate arbiter of the meaning of the Constitution. They're the last resort. Now, I know Nick did not say that, but it really is part and parcel. And whether Nick believes that or not is another question, but generally these things go hand in hand. The view that the federal court system is the final say on the meaning of the Constitution for these United States. And then, of course, well, they're the last line in the sand, the last bulwark, the final bulwark to protect liberty and against tyranny. Now, neither of them are true. And this is not one of those things where it's like, oh, this is how it was supposed to be. And then I'm going to go into this explanation of how, well, yeah, this is how it's supposed to be, but things have really gone off the rails, and now we just got to get it back on track. No, they were never, ever intended to be like this. None of the founders counted on part of the federal government to stop the federal government from doing things that the federal government was never supposed to do in the first place as the last bulwark of tyranny. Here's how Thomas Jefferson put it. I think this is the best way to sum it up. This is a letter to William Charles Jarvis in September of 1820. He said, "You seem to consider the judges as the ultimate arbiters of all constitutional questions. A very dangerous doctrine indeed, and one which would place us under the despotism of an oligarchy." And this wasn't just a one-off for Jefferson, as you'll see as I cite some other stuff from him later in the show. This is kind of a continuous, consistent viewpoint from him. If you rely on part of the government to have the final say over what your Constitution means, you're really on your knees begging for permission. Again, you seem to consider the judges as the ultimate arbiters of all constitutional questions, a very dangerous doctrine indeed, and one which would place us under the despotism of an oligarchy. Thomas Jefferson continues, and he points out why. Because they're just human beings that sit on the courts, and human beings of all stripes and in all positions of power are susceptible to, well, the issues of power in and of itself. He said, "Our judges are as honest as other men, and not more so. They have with others the same passions for party, for power, and the privileges of their core." So just like any other position of power, any other branch of government, as long as you rely on people in power to do the right thing, as Patrick Henry warned us in the Virginia Ratifying Convention, you shouldn't be surprised that you're going to lose liberty. He said it happens every time after every such mad attempt. Here's James Madison in his, what we could call the famous report of 1800. He said, "Dangerous powers not delegated may not only be usurped and executed by the other departments, but that the judicial department also may exercise or sanction dangerous powers beyond the grant of the Constitution." So they may get involved in stuff they were never supposed to do. And this is, mind you, this is more than a century before the incorporation doctrine went into kind of practice. And they also may sanction, act like a rubber stamp. So Madison is explaining why you can't count on them to be the final say over the meaning of the Constitution for the people of the United States, because you're giving the created the power over the creators. Going further, he said, "Consequently, The ultimate right of the parties to the Constitution to judge whether the compact has been dangerously violated must extend to violations by one delegated authority as well as by another, by the judiciary as well as by the executive or the legislature. So the parties to the Constitution are the ultimate final say, the ultimate arbiter of whether or not their Constitution has been violated. And this doesn't just mean acts of Congress. This doesn't just mean executive orders or acts of the executive branch. It also includes the judicial branch. And mind you, even at the top, we'll give them credit on this. When the Supreme Court issues a, quote, ruling, it doesn't say ruling. That's how everyone else reads it, like it's law. But the judicial branch has nothing to do with creating law. They write opinions on the meaning of the Constitution as applied to the case in front of them. Now, many of them, they shouldn't even be taking those cases, but that's another question. Madison continued this train of thought, or he was, in his report of 1800, he was explaining what was going on in the Virginia Resolutions of 1798, which he drafted in response to the hated Alien and Sedition Acts. It was passed on December 21st and 24th, Christmas Eve, 1798. And so he's explaining that. And here's how he put it in 1798 in those resolutions. That this assembly doth explicitly and peremptorily declare, I can never say that one, that it views the powers of the federal government as resulting from the compact to which the states are parties. So who are the parties to the Constitution? They have the final say, is what he said. The ultimate right to decide whether the Constitution has been violated is the parties of the Constitution themselves, not part of the entity that was created by the Constitution. That would be absurd. Jefferson's going to talk about that in a moment, or I'm going to read Jefferson on that in a moment. So he goes on. In case of a deliberate, palpable, and dangerous exercise of other powers not granted by the said compact, the states who are parties thereto have the right and are in duty bound to interpose for arresting the progress of the evil and for maintaining within their respective limits the authorities, rights, and liberties appertaining to them. So again, who has the final say over the meaning of the Constitution? The parties to the Constitution. And he's saying here that they have the right and the duty to interpose against the federal government when the federal government goes beyond the limits of its Constitution. This is this is often very confusing to people. They hear the word states, they immediately think state governments. And Madison explained this as well in the report of 1800, explaining the Virginia resolutions. He said the word state can be used in many ways. We can think of a few of them in modern times, the way that they're used. But he said, it is indeed true that the term states, he put that in quotes, is sometimes used in a vague sense, and sometimes in different senses, according to the subject to which it is applied. Thus, it sometimes means the separate sections of territory occupied by the political societies within each. So you look on a map and, oh, the state of Wisconsin, you know where that is. That's the location. State of California, places that I've lived, of course, the first ones that come to my mind. I love all of you guys, and sorry if I skipped over yours. So sometimes it just means the territory that we're talking about, the area on a map. Sometimes it means the particular government, because the territory is not the same thing as the government as well. So you could be referring to a geographical region. You could be referring to the state government itself. He said sometimes the particular governments established by those societies, and sometimes those societies as organized into those particular governments. And lastly, it means the people composing those political societies in their highest sovereign capacity. So he's really talking about the fact that it is the people of the several states with the highest sovereign capacity. Sovereignty meaning final authority. Again, we're talking about who has the final say. If it's the parties to the Constitution, then it is the people of each state who have their own say on this. It isn't the state government, and it certainly isn't part of the federal government either. Now, this is really just kind of a reaffirmation of what George Mason emphasized back in 1775, many others before him as well. And he said all power was originally lodged in and consequently is derived from the people. Now back to Madison's report, where he hammers home that what he wrote about the states having a duty bound to being duty bound to interpose, he was referring to the people composing those political societies. So he's talking about the people themselves. Now, the people can have their government do stuff for them, but ultimately the final say is the people of the several states. And here's how he put it in the Virginia report discussing this. And hopefully this will all make sense in regards to that post by Nick Carter. In the present instance, whatever different construction of the term states in the resolution may have been entertained, all will at least concur in the last mentioned, because in that sense, the Constitution was submitted to the states, that is, the people composing those political societies. He said, in that sense, the states ratified it. And in that sense of the term states, they are consequently parties to the compact from which the power of the federal government result. So this is the TLDR. The Supreme Court does not have the final say on whether or not the Constitution has been violated by any branch of the federal government, including themselves. It is the people of the several states who hold final authority and have the final say. Now, back to that dangerous doctrine. First of all, let's say, again, power comes from the people. The people of the several states hold sovereignty or final authority. They are also, as James Madison explained, parties to the Constitution, and they have what he called the ultimate right to determine if the Constitution is violated. And with that in mind, here's how we responded in a pretty long tweet and a thread, or a post and thread over there at x.com. Here's how we put it there. Relying on one part of the government to stop another part of the government from doing what the government should. Let me start it again. Relying on one part of the government to stop another part of the government from doing what the government shouldn't have been doing in the first place is not a bulwark against tyranny. It guarantees the tyranny in the long run. Ultimately, it's up to the people and the states to keep the feds in check, and ultimately, it's up to them to do it whether the feds like it or not. Now, I'm going to get into a little bit more detail on that in a moment, but first of all, I want to point out that we're going to have a blog post published for this in the next couple of hours after the live stream is done here this morning or afternoon, I guess, whatever, depends where you are. That's published over at 10thamendmentcenter.com/path to liberty. There you're going to find not only all the links that I'm referencing so you can read in context and learn more on your own time. Like I'm citing Madison and Jefferson quite a bit, but I'm just taking bits and pieces. And it's important to understand the full context of what they were writing about. But then you're also going to find all the different platforms on. Of course, we live stream on the mainstream ones, YouTube and Facebook and Twitter and LinkedIn and Twitch, and man, I'm sure there's another one. But we also live stream over on the ever awesome Odyssey.com, ODYSEE.com, and Rumble.com. And we have the audio-only podcast version everywhere possible. If we're missing from a platform you love to see us on, just let us know in the comments or email team@10thamendmentcenter.com. Let me take a look over at the live chat and say a quick hello to everyone here. I appreciate you being here with me. Whether this is your first episode or you've been here for every single one since day one, there's Haji and Tim Martin, Douglas Fox, Dixie, John, and Sparrow, Senator DT, John, and a few others. I appreciate you guys being here. Thank you so much. I'll take a look over at Douglas Fox. I appreciate this. Smash that like, everyone. If you're on any of the mainstream platforms, hitting the like, leaving a review on the podcast platform, subscribing, getting notifications, all those things tend to kind of help us reach more people. And in many situations, it tells the algorithm of the platform that, oh, people are interested in this. They're engaging. They're watching a lot of it or listening to it. So we want to show this to more people. So the more that you interact with it, the more it helps us out. And I really appreciate that a great deal. But nothing helps more than sharing the links on whatever various platform you happen to use the most, sharing links to the show, especially after it's done, so people can listen or watch on their own time. Anyways, let's get back to it again. 10thamendmentcenter.com/path to liberty is where you're going to find the blog post that Alan Mosley will be putting together in the next few hours. So here's how John Hancock put it. This is in the Massachusetts Ratifying Convention. I believe it was February 6th. This may have been the last day. Basically, Massachusetts was going to vote against ratification. But Hancock, Samuel Adams, and a few others made deals with people like Theophilus Parsons and some of the other Federalists to say, okay, if we can recommend amendments, we will approve the Constitution. We'll vote, and then we'll give our list of recommended amendments, and a gentleman's deal. You know, we've been through a revolution together where no one's going to break this deal. we're going to get amendments soon after. Now, Samuel Adams wasn't too happy with that process. As a quick aside, he was writing, even after ratification, that it was clear that the Federalists were delaying. They were trying to get away with not doing it, so they were already trying to break their promise. So he was writing to people in Congress like Elbridge Gerry, and Richard Henry Lee to say, hey, what's going on? We're getting a little impatient about this. But anyways, the first recommended amendment that Massachusetts included was a precursor to what became the 10th Amendment. Now, Thomas Jefferson thought it was too restrictive in some letters back and forth, but he liked the process and the strategy of doing this. And when John Hancock said, okay, let's go and support this, it was a very close vote in Massachusetts. Hancock really helped push it over the top. It was because they were including this recommended amendment and agreeing on the structure that the government would only have those powers expressly delegated to it. And he said it this way: the powers reserved by the people render them secure. Now, he wasn't talking to the people of the several states. He was talking to the people of Massachusetts. The powers reserved to the people render them secure. It's not the federal courts will render them secure. He never said that. He said the powers reserved by the people render them secure. Now, ultimately, it's up to the people to use them to render themselves secure in support of liberty rather than whatever they've been using it for, for generations. That's how John Hancock put it. James Iredell, who was one of the first associate justices of the Supreme Court. Here's a founding father, a framer, a very important legal mind and figure at the time. He was nominated by George Washington to be on the Supreme Court. And while Nick may say on Twitter that the final bulwark against tyranny is the courts, here's one of George Washington's Supreme Court justices saying something completely different. No, that's not the case. He put it this way: the only resource against usurpation is the inherent right of the people to prevent its exercise. The only resource against usurpation is the inherent right of the people to prevent its exercise. That's how Supreme Court Justice James Iredell put it. He continued, this is the case in all free governments in the world. The people will resist if the government usurp powers not delegated to it. So when government enacts arbitrary measures, they steal power from the sovereign people of the several states. That's usurpation. It's not part of the federal government that is our last line in the sand to stop that tyranny. According to James Iredell and many others, it's the people of the several states themselves. Roger Sherman put it like this in a letter in December of 1787. He said, all acts of the Congress not warranted by the Constitution would be void. That's a principle, a theory. So if they violate the Constitution, it's not a law. It's only supreme law if it's in pursuance of the Constitution. But Roger Sherman recognized that when government does stuff that they're not supposed to do, you can't just wave a paper at them and say, oh, that's void. You're not authorized to do that. And so therefore they just back down. No, they're going to try to enforce whatever they've passed anyways. But he pointed out that as long as the states, and that means the people of the several states, and maybe they utilize their state governments to get involved, if the people and the states resist them, they can't enforce that. So all acts of the Congress not warranted by the Constitution would be void, nor could they be enforced contrary to the sense of a majority of the states. And of course, there's Thomas Jefferson once again, who told us that any time the federal government exercises powers not delegated to them, a nullification of the act is the rightful remedy. Not just a mere good idea to try later, not something to wait till the very end until things get so bad that you live under the largest government in history, but it's the rightful remedy whensoever they exercise powers not delegated to them. And he continued saying, every state has a natural right in cases not within the compact to nullify of their own authority all assumptions of power by others within their limits. Without this right, they would be under the dominion, absolute and unlimited, of whosoever might exercise this right of judgment for them. So if you go to the government and you ask part of the government to protect you from the government doing things that they were never supposed to do in the first place, and you sit around and you wait for them to do the right thing, and sometimes they get it right, and most of the time they get it wrong, even if they get it right 100% of the time, you are ultimately under the dominion, absolute and unlimited, of those unelected, unaccountable, politically connected lawyers exercising this right for the people of the several states. So the TLDR, or the TLDW, allowing the federal courts to have the final say on your liberty is putting the people in the states in a place of unlimited submission. And that's what Jefferson started this resolution with. Let me see if I can get to the top here. It's pretty long here. He said, the United States are not united on a principle of unlimited submission to their general government. He started it out with that. So basically the idea that you have to wait for the government to tell you that the government made a mistake is unlimited submission. This is not a people living in a land of the free. This is a population on its knees begging for scraps. Let's go to Lysander Spooner. I think this is always a nice touch. In A Defense for Fugitive Slaves, which I cite all the time, you got to read it. It's awesome. I will link to it in the show notes. Alan Mosley will link to it in the show notes, and I'll get it published a little bit later today. He said, the idea so constantly asserted that the permanent judiciary, the judges, have a right to decide all constitutional questions authoritatively for the people is one of those gross impostures by which men have been always defrauded of their rights. So this is just a Spooner-esque way of reiterating what Thomas Jefferson had to say so many years earlier, about 50 or so. And going further, Spooner then points out that waiting for the government that is violating your rights to stop doing the things it wasn't supposed to do in the first place is, in essence, like Thomas Jefferson said, giving them unlimited power. He said to say that an unconstitutional law must be obeyed until it is repealed is saying that an unconstitutional law is just as obligatory as a constitutional one, for the latter is binding only until it is repealed. So to Lysander Spooner, if the Constitution is the supreme law of the land, it doesn't matter what the government happens to say about it. If it violates the rules and the people believe that it violated the rules, then they don't have to wait for the government to stop doing what the government wasn't supposed to do in the first place. Spooner continued, there would therefore be no difference at all between a constitutional and an unconstitutional law in respect to their binding force, and that would be equivalent to abolishing the Constitution and giving the government unlimited power. It's literally the same type of principle that Thomas Jefferson said in 1798. If the government has the final say, if they are the final bulwark against tyranny, the final say about what government should or should not be doing, you are giving the courts unlimited power. And here's how Jefferson put it. Well, if that's not it, what is it? He said, I know of, and this is in the same letter to William Charles Jarvis, September 1820. Again, that'll be linked to in the show notes, 10thamendmentcenter.com/path to liberty. Jefferson put it this way. I know no safe depository of the ultimate powers of the society but the people themselves. And if we think them not enlightened enough to exercise their control with a wholesome direction, which is absolutely true today, the remedy, Jefferson said, is not to take it from them, but to inform their discretion by education. This is the true corrective of abuses of constitutional power. In other words, don't take away their power and give it to government, because government in the long run will never do the right thing. The true corrective for a population that has been propagandized from cradle to grave by government-approved sources day in and day out is not to continue giving the government more power. It is to educate the people on what is right and wrong and what their duty and rights are. Spooner put it this way, the right of the people, therefore, to resist usurpation on the part of the government is strictly a constitutional right. I think that's an interesting phrase that he called it constitutional rights. I disagree. He said, the exercise of the right is neither rebellion against the Constitution nor revolution. It is a maintenance of the Constitution itself by keeping the government within the Constitution. The only way, the inherent right of the people to prevent its exercise, is how James Iredell put it, in 1788, and that's the only resource against usurpation. When government does stuff it's not supposed to do, the only way to stop them is the people of the several states themselves. And Spooner is taking virtually the same position. Jefferson summed it up like this: a free people claim their rights as derived from the laws of nature and not as the gift of their chief magistrate. It doesn't matter if that chief magistrate is ultimately an executive branch official or in Congress or on the Supreme Court. As long as people are waiting for government to give them permission to do what they're already authorized under their own natural rights to do by being a human being, if they're waiting for government to give them permission to do that, they're not really free. A free people are those people who learn how to exercise their rights, whether the government happens to like it or not. Well, I've got another minute or two here. Let me see if I can answer some comments or questions here in the live chat. Haji says, this is inspirational and informative, Michael. Thank you for sharing their wisdom and your application of it to our circumstances today. Well, I'm really glad you find it interesting, Haji. I really, really appreciate it because, ultimately what I'm doing as I do this show, and I think if I look back over the number of years, I might be close to episode 1,000. One of these days I'm going to start numbering them, but it's a little overwhelming at this point. I'm in the 700 or 800s. But as I look back on some of these, even my messaging on some of these have just gotten better and better and better, because looking at this stuff day in and day out and looking through more documents and through articles and papers and essays and books, the more I read them, the more things become a little bit more clear to me on how to apply the wisdom, the strategy, the strength, and the understanding of the founders and the old revolutionaries to our, what we live under today. And I am no expert. I am not doing anything that you couldn't do as well. So I'm just trying to share with you on my own journey what I'm learning on how to support the Constitution, how to protect and advance liberty when government refuses to do so, which is constantly 24/7, 365. And nothing helps us get that kind of work done more than the financial faith and support of our members. If you got a couple of bucks of that dirty government fiat, please consider throwing it our way. It's an investment in the Constitution. It's an investment in advancing liberty. It's an investment in educating people in the future, people everywhere, as much as possible. 10thamendmentcenter.com/members. We make a tiny amount, go a long, long way. I'd be very grateful for any consideration you can give to joining us today. Senator DT points out that the general government was only given the authorities of war, peace, negotiation, and foreign commerce. They were never part of the compact. Yes, the important part is the federal government didn't create itself. So if the parties to the compact have decided that the compact has been violated, to hell with the opinion of the federal courts, the federal politicians, and all of their supporters. It doesn't matter. Ultimately, the final authority has always been with the people. James Wilson put it that way. Sovereignty remains with the people. It never just had to be established by a gift from government. That's absurd. That's an important point. I'll take a look over in the live chat a little bit later on today and see if there's any comments or questions that I can get back to. You can also leave us a comment in the archive. As I mentioned earlier, that helps trigger the algorithms. You can email me, team@10thamendmentcenter.com. I don't get back to very many of them, but I do read through almost everything possible, especially the comments and the emails, because it gives me so many great ideas for future episodes. It makes me think about things that I could do better in current and previous ones, and I'm always trying to learn, expand, and grow, and help and reach and teach more and more people about these essential foundational principles and how to put them in practice today. Anyways, again, I really appreciate you being here. I hope you enjoyed this information as much as I enjoyed putting it together and sharing it with you. I hope you have a great day. As a quick reminder, I will be off most likely all next week because we've got some construction, I've got family visiting, all kinds of stuff going on over here. So it's very unlikely I'll be able to do some episodes. If I can, I will. If I have extra time, I'm going to do one because I love doing this stuff. But it's very likely that I won't be around to do live shows next week. But I appreciate you being here. I hope you have a great day, and I hope to see you next time here on the Path to Liberty.